Hello everyone. Today we are going to talk about an interesting story in business law. That is, a case law named Gunthing versus Lynn, which comes under the contract law. We are planning to discuss this story under three main sections, namely the facts of the case, the issues of the case, and who won the case and why. Before we start off with the case law, let's get to know some basics first. First of all, let's look at what a contract is. A contract can be known as a legally binding agreement between two or more parties. For an example, all everyday transactions we do can be taken as contracts. When talking about contracts, there are 6 main elements that need to be discussed in order to understand the contract law. The first element is an offer. This simply means in order for some party to get into an agreement, he or she should offer a set of terms and conditions. The second element is an acceptance. This simply means an agreement to specific terms and conditions that are included in an offer. The third element is an intention to be legally bound. And the fourth element is a consideration. Here each party provides a consideration to the other. The consideration can be a promise to pay money, a promise to do something, or a promise to not to do something. And the fifth element is legality and capacity. Here, a legal requirement should be in between people who have the full capacity to contract. And the final element is certainty. This simply means a valid contract requires reasonable certainty level. These are the main requirements that needed to be fulfilled in order for a contract to come into existence. Now we'll take a look at the Gunthing versus Lynn case law, which is a scenario happened between a horse seller and a buyer.
Now let me point you out the facts of this case. So here, according to this case, there is a horse seller who is the defendant of this case and the buyer who is the plaintiff of the case. According to this case, the buyer promised the seller that they would pay £5 extra for the horse or buy another horse from the seller if the horse was lucky for the buyer. But here the buyer is not satisfied with the conditions of the horse, therefore a dispute arose between the buyer and the seller. So here the case is whether the seller was owed the conditional payment which was mentioned by the buyer earlier.
When talking about the issues with regards to this case, we can identify two major issues that the court had to come across. Number 1, what did the buyer mean by lucky? The court was engaged in determining if the offer from the buyer to pay more for the horse in the amount of £5 if it was lucky could be a valid offer for the purpose of the sale, as being lucky is not a valid measurement in terms of this purchase. More specifically, the court was required to understand if the terms lucky and buy another horse could be defined as legally binding on the two parties.
Second point would be the agreement between the buyer and seller being a verbal agreement. Although the case goes by saying that the buyer laid down the condition of paying more or buying another horse if the horse was lucky, this was a verbal agreement. The absence of any physical evidence to prove that such an agreement was to be met was another issue that the court had to follow up on, leaving the court with the suspicion of whether this agreement was one that actually happened.
The court held that the condition to pay extra $5 for the horse if it was lucky was not a definite offer to create a binding contract between the parties. The term lucky in this case is not a definite term, as it cannot be clearly identified and evaluated. In order to offer to be valid, it should be clear and straightforward, or else it should not be too vague. As a result of this, the only part of the transaction that was sufficient for the court was the purchase of the horse for the price of $63, which was the vast majority of the legal agreement between the parties.